Counsel for Defendant R.J. Reynolds.
Thank you, Your Honor. May it please the Court, Counsel, Mrs. Piendle. Good afternoon, ladies and gentlemen of the jury. As you know, I'm Peter Biersteker, together with my partner, Liza Kessler, and John Wiederhold. We are proud to be here representing the R.J. Reynolds Tobacco Company. One of the working men and women from the R.J. Reynolds Tobacco Company, Mr. Ben Shipley, is here with us today. Of course, you know that Mr. Kelly and Mr. Hank represent Philip Morris. They'll introduce themselves in a minute. I thought I would tell you who the last member of our team is, and he's helping us out with graphic support, and I'm not making this up. His name is Will Farrell. I wanted to start, before we get into what this case is about, by talking a little bit about what it is not about. And you heard some of this during the jury selection process, but I think it's worth mentioning again. The first thing this case is not about is whether you like or dislike cigarettes. Not an issue. Next thing, it's not whether or not cigarettes should be sold. They are a legal product in this country. A dangerous, but a legal product. And Congress made that decision, that cigarettes should continue to be able to be sold, despite the health risks. Just as we as a society have decided that other products with health risks can be sold. So, for example, we're free to buy and purchase alcoholic beverages that do come with a warning. We're free to go to McDonald's and get supersized anytime we want. We're free to ride a motorcycle instead of a car that has a 5-star, crash rating. I wanted to say something else about the warnings. Congress not only specified what the language was, but they've been on the packs of cigarettes, as Your Honor told you when you started, since 1966, nearly 45 years now. And this case is not about, at least since July 1st, 1969, whether those warnings are adequate. Nobody is going to dispute that. Nobody is going to claim that R.J. Reynolds or Philip Morris should have put a different warning on or an additional warning on cigarette packages after that date. Another thing this case is not about. This case is not about whether you like being around cigarette smoke or cigarette smokers. It's not about whether you like or you dislike tobacco companies. It's like liver, maybe, to Mr. Scarola, but that's not an issue for you in this case. It's not about whether you like companies, whether they be big companies like pharmaceutical companies, or they be small companies like the family restaurant down the street. Not an issue in this case. This case is not about whether or not smoking can cause lung cancer.
Not about argument, not about
I'll sustain and have you discuss with the board what the evidence will show.
All right. I just wanted to say that in this case, you'll learn that 85 to 90% of lifelong smokers do not get lung cancer. But as Reynolds has admitted, and Philip Morris has admitted for a long time now, cigarette smoking can cause lung cancer, and Mr. Piendle was one of those folks who got lung cancer, and it was caused by his smoking. Nobody disputes that. Mr. Piendle died at age 55, and we all feel sympathy for Mrs. Piendle. That was far too young. We wouldn't be human if we didn't feel that way. But that, too, is an emotion you need to put aside and focus on what the evidence will be and what this case will be, what the evidence is and what the issues are in this case. And it's a big job and it's a big responsibility. So now let's talk about what the case is about. I suppose ultimately it's about whether Mrs. Piendle, on behalf of the estate of her husband, Mr. Piendle, is entitled to get money from R.J. Reynolds and Philip Morris. And that means, I think, that the first thing this case is about Mr. Piendle. And I'm going to give you an overview of what I'm going to talk about. I really kind of want to talk about three things here with you this afternoon. First, I want to talk to you about Mr. Piendle and tell you a little bit about what I think the evidence that you will hear during the course of this trial will show about him, and especially his decisions to smoke and to continue smoking, what he knew, what information was available to him, when and how he quit, and the kind of man that he was. Okay. Second, I want to discuss some of the issues. And Her Honor read to you instructions this morning, and if you're like me, it's really hard to listen to that, and I'm a lawyer, and to follow it completely. So I wanted to kind of summarize what I think the issues are that you will confront when you ultimately retire to deliberate about this case, and talk about how the findings that you've heard about, and talk about how the evidence you will hear relates to those issues. The third thing I want to talk to you a little bit about is patience, and goodness knows you've showed us a lot of patience so far, but I'm going to be talking about a little bit different kind of patience. Okay, so let me kind of give you an overview of those three topics where I think we're going to be, and then I'll start with Mr. Piendle. Here's the overview. The overview is that the evidence will show that nobody forced Mr. Piendle to smoke. Nobody tricked him. He didn't start smoking out of ignorance, you will learn. He called cigarettes cancer sticks when he was in high school, back in the late 1950s, and that's when the evidence will show he either started smoking or he was only smoking once in a while. I'll explain that in a minute. And everybody referred to cigarettes as coffin nails. Okay, over the years, Mr. Piendle received thousands of warnings, including the warnings that were on the packs, about the health risks of smoking. And despite knowing the health risks of smoking, Mr. Piendle, a former Marine, who was strong-willed, not weak, and pretty much did what he wanted to do when he wanted to do it, enjoyed smoking, and he chose to smoke. Okay, what will the evidence be about quitting? Again, this is just a summary. There will be no evidence that Mr. Piendle ever tried or wanted to quit in the 1950s and 1960s. You'll hear about some New Year's resolutions that Mr. and Mrs. Piendle made in the 1970s and in the 1980s. But the evidence will be that they weren't that serious, and they weren't even that memorable to Mrs. Piendle. The evidence will finally be, as you've heard before, that in 1989, Mr. Piendle made a choice, and he just quit. He went cold turkey, and apart from being a little moody, which could have been due to a number of different things, he didn't exhibit the other symptoms that people who are addicted experience when they quit. He just quit. He never picked up another cigarette, despite the fact that Mrs. Piendle was still smoking. Now, you'll learn that if Mr. Piendle had quit smoking sooner than he did, he probably would have avoided his lung cancer. The extra risk of lung cancer that smokers have compared to people who have never smoked starts to go down after they quit. The extra risk they have starts to go away. Finally, the end of the overview. There will be no evidence that anything that R.J. Reynolds and Philip Morris did or did not do, other than selling cigarettes, which is perfectly legal, caused Mr. Piendle to start or kept him from quitting smoking. And the evidence will also be that this is not an appropriate case for punitive damages. All right, so let's start at the beginning, and let's start with Mr. Piendle, and let's start at the beginning of his life. 1941, that's when you heard he was born up in Connecticut. He grew up there. He and Mrs. Piendle did not move to Florida until about 1980, when Mr. Piendle was about 39 years old. And we heard Plaintiff's counsel in his opening describe when Mr. Piendle started smoking. And I think the evidence will show that we don't really know when he had his first cigarette and started to smoke. Mrs. Piendle, of course, didn't know him. They didn't meet until 1968. They got married in 1969. And there will be testimony from individuals who knew Mr. Piendle when he was in high school, and their testimony is going to vary a little bit. Not everybody says the same things. Now, Plaintiff's counsel brought to your attention that one of his classmates, the guy he played football with, will testify that Mr. Piendle started smoking in the 6th, 7th, or 8th grade, somewhere in there. But another friend will say he started smoking in the 9th grade. And when you talk to his brother and sister, they'll be here, either live or by videotape, that they don't think he started smoking until he was a junior in high school, which would have been about 1958. And finally, you'll learn that Mrs. Piendle thinks that Mr. Piendle started smoking in 1959. So it's hard to say exactly when Mr. Piendle started smoking, other than that it was probably between 1953 and 1959, when he was somewhere between 12 and 18 years old. Okay. Now, regardless of when he picked up that first cigarette, the evidence will be that Mr. Piendle didn't smoke very much when he was in high school. In high school, as plaintiff's counsel has advised, the evidence will be that Mr. Piendle was an athlete, a star football player, a halfback on the team. And nobody dared to smoke in front of the football coach. In addition to football, Mr. Piendle participated in other sports, such as gymnastics and track. Even his football teammate and his friend from back in his high school days, who says that Mr. Piendle picked up that first cigarette between 6th, 7th, 8th grade, will testify that Mr. Piendle only smoked once in a while when he was in high school. All right, so why did Mr. Piendle pick up that first cigarette? Well, we don't really know that either. As far as I know, he never told anybody why he started smoking, and I don't think anybody ever asked him. What will be clear is that both of his parents smoked, his friends smoked, all of which made it more likely that Mr. Piendle was going to start smoking. And there will be evidence that he wanted to fit in with others, just like many folks during the course of our jury selection process said they started to smoke because of peer pressure or rebellion. That's not because of anything defendants did. The truth of the matter is a lot of people smoked in the 1940s and 50s. All right. The evidence will be that in high school, Mr. Piendle knew that smoking caused cancer and death. He called the cigarettes cancer. He called cigarettes cancer sticks when he was in high school, and everybody referred to them as coffin nails. Now, you'll also learn that Mr. Piendle was a curious guy. He was intelligent, and he had an interest in current events. For example, Mrs. Piendle, I expect, will testify that he loved to read the newspaper cover to cover every day. Smoking and health issues, you will learn, were covered in the media in the 1950s as the scientific evidence linking smoking to lung cancer began to emerge. So when an article was published, for example, in a scientific journal, oftentimes it was picked up in the lay press, from Reader's Digest and Life magazine, and in things that the common man would certainly have read. Smoking and health, you will learn, was also a subject taught in the schools that Mr. Piendle attended, just as it is today. You'll also find out about a survey that was taken of high school seniors in 1959. I'm sorry, I have to take that down. You have to take that down, please. Thank you. A survey of high school seniors in 1959, in which they were asked, have you heard whether smoking causes lung cancer? And 90% of high school seniors in 1959 had heard that, and in fact, about 90% of the junior high school students had heard it. When I said 90% of high school seniors, I meant 95. A lot of folks had heard it. And even before Mr. Piendle was born in 1941, the fact that once you start smoking, it can be hard to quit was well known. That's been known for hundreds of years, literally, that once you start smoking, it can be hard to quit. You will learn that Mark Twain, famous American author in the mid-1800s, said, "It's easy to quit smoking, I know, because I've done it thousands of times." He was kidding, of course, but it makes the point that quitting smoking, even back then, was recognized as something that's hard to quit. There was even a song. It was on the top of the pop charts in 1947, the #1 hit, and Mr. Piendle would have been in elementary school at that time. And the song was called "Smoke, Smoke, Smoke, Smoke That Cigarette." And it used the phrase "nicotine slaves," and it said if you get to heaven and you have to tell St. Peter to wait at the Golden Gate because you got to have another cigarette. And it was all about how hard it can be to quit and making fun of people who smoked and had to interrupt daily activities. Okay, so in short, with respect to smoking and health and the fact that smoking could be hard to quit, the 1950s were not, like the fictional Mad Men show that we talked a little bit about during jury selection, an age of complete ignorance about the health risks of smoking or the fact that it can be hard to quit. You heard plaintiff's counsel refer to this. There was evidence that the average guy responded to the information that was coming out in the 1950s. They talked about the dip in cigarette consumption that occurred in about 1950, 1952, 53, in that area. And in addition to that dip in consumption, what happened is those people who continued to smoke started to switch en masse to filtered cigarettes and away from the unfiltered cigarettes. the popular knowledge, the common man's information was they were keeping abreast of the information that was coming out with respect to smoking and health very regularly in the 1950s. But Mr. Piendle started smoking anyway, smoking only once in a while in high school, and there will be no evidence that he tried to quit when he was in high school, despite what he knew. Okay, let's talk about, that sort of takes care of his high school days. Let's move to the 1960s and talk a little bit about what happened then. Mr. Piendle graduated from high school in 1959, and he enlisted in the Marines. And as you heard, the evidence will be that he wanted to make a career out of the Marines. But unfortunately, he got Crohn's disease, which was described to you by Mr. Barnhart. I won't repeat that. And he was discharged medically from the Marines with a temporary disability in 1962. The evidence will be that by the time he was discharged from the military, Mr. Piendle was certainly a smoker. Depending upon which medical record you look at or whose testimony you hear from, he smoked somewhere between maybe a half a pack at the low end and 2 packs per day at the high end. It's hard to say exactly how much. Most of the evidence that you will hear will suggest that he smoked about a pack and a half a day. Okay, and he did that for a long time. And you'll learn through the evidence in this case that in the 1960s, the health risks of smoking were again widely publicized. For example, there was reference made to the 1964 Surgeon General's report. It was the first Surgeon General's report that was published. It concluded smoking causes lung cancer in men. That's what it said. And it was big news. It was news not just for one day. It bumped the Kennedy assassination, which had occurred in 1963, off the front page of the newspaper. The report came out in January of 1964. And then you'll hear about the warnings. And Your Honor read them to you. I just wanted to put them up on the screen. In 1966, caution, cigarette smoking may be hazardous to your health. And you will learn, if somebody put a warning like that on this pen, we might all scratch our heads. But in the context of the informational environment that was out there, what people already knew in 1966, everybody knew what that was a reference to. Okay. I'm getting a little bit ahead of myself, but why don't we finish the warning story? In 1970 to 1985, that was the warning. Warning. The Surgeon General has determined that cigarette smoking is dangerous to your health. And then we have the warnings that have been on the packs since 1995 to the present. Smoking causes lung cancer and other diseases. Surgeon General's warning, quitting smoking now greatly reduces serious risk to your health. There's a warning about pregnancy. And there's a warning that cigarette smoke contains carbon monoxide.
It's 1985.
Is that not what I said? If I misspoke, I misspoke. It's 1985. Thank you, Counsel. Now, you'll learn that the United States government wrote all of these warnings, and they appeared on each and every one of the packs that Mr. Piendle smoked for over 20 years, starting in 1966. And they were in every cigarette advertisement of the major tobacco companies, including R.J. Reynolds and Philip Morris, starting in 1972. So all those ads that Mr. Barnhart referred to in his opening as enticing people back to smoking, to relapse, had these warnings starting in 1972. The evidence will show that for Mr. Piendle, these warnings weren't necessary. He knew about the dangers of smoking, again, back when he was in high school, but he continued to smoke anyway. You'll also learn that the American Medical Association in 1964, when Congress was, mid-60s, 64 or 65, when Congress was considering putting that first warning on the pack of cigarettes, the American Medical Association took the position the warning wasn't necessary because the health risks of smoking were already common knowledge. And later in the 1960s, when they changed the warning, so it would say, is dangerous. In 1968, you'll learn that Daniel Horn, he was a scientist, again.
Your Honor, that's the issue of preemption that the defendants agreed related to the sufficiency of the warnings. I thought that was going to be excluded.
Well, it's 1968, Your Honor, it's before 1969.
Same issues.
No.
I'll have Counsel first.
You'll learn that in about 1968, Daniel Horn, who was with the United States government scientist there, said you could shout smoking is dangerous from the rooftop and you wouldn't be telling anybody anything that they didn't already know. And the evidence will show again that that was certainly true for Mr. Piendle. You wouldn't be telling him anything he didn't already know. Now, of course, in the 1960s, Mr. Piendle was seeing doctors more often than most people his age because of his Crohn's disease. And you will learn that he filled out medical records, medical forms, many times over the years that asked him about his smoking. In short, there will be no evidence that Mr. Piendle somehow forgot what he already knew in the 1950s, that smoking caused cancer and death. And there will be plenty of evidence to show that during the 1960s, Mr. Piendle's knowledge about the health risks of smoking could have only been reinforced by the information around him. Yet there will be no evidence, again, that he tried to quit in the 1960s. There was also a happy event in the 1960s. I don't want to leave it out. In 1968, Mrs. Piendle met Mr. Piendle at a karate class, and they got married in 1969. And I bring that up in part for a reason. In 1969, Mr. Piendle switched smoking from Marlboro cigarettes, made by Philip Morris, to Winston cigarettes, made by my client, R.J. Reynolds. And why did that happen? Mrs. Piendle was smoking Winston cigarettes, and she got Mr. Piendle to switch. For the next 20 years, Mr. and Mrs. Piendle smoked the same cigarette brands. Why? Well, for 20 years, Mrs. Piendle bought cigarettes for both herself and for Mr. Piendle. Mr. Piendle smoked whatever cigarettes Mrs. Piendle bought. Mrs. Piendle bought a lot of brands over the course of the year. They tried lots of different cigarette brands. But their main brands, after Winston, were Raleigh, Durrell, and Merit. The principal consideration in deciding which brands to smoke as their regular brands was taste and sometimes price. Okay, let's move to the 1970s and the 1980s. In the 1970s and 80s, there will be even more evidence that Mr. Piendle knew the health risks of smoking and knew that smoking can be hard to quit. Apart from the warnings and the news, remember Mr. Piendle liked to read the newspaper, that he read and heard, there were events like the Great American Smokeout. I don't know how many of you remember hearing about that, but you'll learn that it's a day in which smokers across the country are encouraged not to smoke for just one day, in the hope that one day becomes 2 days become 3, etc. There were increasing restrictions on where you could smoke, starting with airplanes in the 1970s. They put in a smoking section. Before then, you could smoke anywhere in the airplane. In the 1970s, there was a separate section for smokers on airplanes. And you will also learn that Mr. Piendle was told to quit smoking by his friends and family. All right, so let me just review some of those. Mrs. Piendle had a son from a prior marriage. His name is Alan Canozo. He was born in 1966, and you'll learn that Alan urged Mr. Piendle to quit because it was not good for him in the 1970s or the early 1980s. And Mr. Piendle ignored his stepson's advice and continued to smoke. Alan, nonetheless, himself later started smoking. And in the early 1980s, Mr. Piendle told Alan to quit. But Mr. Piendle ignored his own advice and did not do so. Mr. Piendle's sister, a woman by the name of Christy Varelli, she, I anticipate, will be appearing to you on a videotape because she still lives up in Connecticut. She gave some testimony. It's been taped, and we'll play it for you. That his sister, Christy Varelli, quit smoking in the 1970s. And after she quit, she preached to Mr. Piendle to quit smoking. And Mr. Piendle ignored her advice and continued to smoke. Lucille Warbell, who I think was among Mr. Piendle's best friends, going all the way back to high school, and now lives down here in Florida, quit smoking in the 1970s along with her husband. And when the Piendles moved down here to Florida in 1980, she told Mr. Piendle to quit, and he didn't do so then either. As you heard, Mr. and Mrs. Piendle had a daughter, Tracy Piendle. She was born in 1970. And she went to school, and she got taught about the health risks of smoking, and she, too, preached to both Mr. and Mrs. Piendle that they ought to quit, going so far as to go and get a pack of cigarettes, to take the warning, and to go and talk to Mr. Piendle about it in an effort to get him to quit smoking. Mr. Piendle ignored her advice, but as Tracy got older, Mr. Piendle told her not to smoke. And you'll learn that he said, "Do as I say, not as I do." Mr. Hamill, a friend of Mr. Piendle's down here in Florida, quit smoking. He had a prescription of some kind in 1986. And he told Mr. Piendle to quit, and Mr. Piendle ignored that advice too. Mrs. Piendle, I anticipate, will testify that Mr. Piendle knew the health risks of smoking in the 1970s and 80s. So what did Mr. Piendle do with all this information? He continued to smoke. It was a choice. He had the right to make that choice. He was an adult. Now, you heard a little bit about New Year's resolutions and attempts to quit. But the evidence will be that they were not that memorable to Mrs. Piendle. The evidence will not be clear about how many times the Piendles made New Year's resolutions to quit smoking. It might be 3. Mr. Barnhart, I think, said 5 during his opening. But at least when Mrs. Piendle was deposed in this case, she really couldn't remember how many. It also won't really be clear when Mr. and Mrs. Piendle made their New Year's resolutions. I think there will be testimony that there was one attempt at least up in Connecticut in the 1970s before they moved to Florida, and some subsequently when they got here to Florida. But Mrs. Piendle can't really remember when they occurred. And for those New Year's resolutions, you will learn that most, if not every time, the Piendles didn't actually quit. What they did is they cut down. I'm only going to have 1 cigarette every 2 hours. And they were cutting down as a prelude to maybe quitting later, but not as an attempt to quit altogether right off the bat. You will learn that when the Piendles made these New Year's resolutions, they didn't go to their friends and family and say, "Hey, we're going to quit smoking. We made a New Year's resolution." And ask yourself, as you listen to the evidence, if the Piendles were really determined to quit, wouldn't they tell their friends and family so that they could get extra support, for example? The Piendles, I think Mr. Barnhart said, hid their ashtrays. They put them in the cabinet. If you're really committed to quit smoking, ask yourself, as you hear the evidence, whether that's what you do, or do you throw them out? You'll also learn that the Piendles, when they made these New Year's resolutions, never sought any outside assistance. They never went, Mr. Barnhart talked about how there are additional prescription drugs these days, and the nicotine patches that didn't exist back in the 1970s and 80s, and he's right. But you will learn that there are lots of other things. You will learn that the American Cancer Society regularly sponsored smoking cessation clinics. You will learn that there was hypnosis and there was acupuncture. I think in the 1980s you could get nicotine gum with a prescription. But the point is that in association with none of these New Year's resolutions, as you will learn, did the Piendles go and seek any kind of help at all. In short, the evidence will be that before they even made the New Year's resolutions to quit, the Piendles were making it easier to fail. You don't have to have disappointed friends and family members if you're a secret quitter. You just get the ashtrays back out of the cabinet and you don't get any help. So it shouldn't come as much of a surprise that the evidence you will hear from Mrs. Piendle, who was there and who participated with Mr. Piendle in these attempts to quit on New Year's, will be that in connection with these various efforts, at most, they quit for a day, maybe 2. Okay. The 1970s was sort of a rough time for the Piendles. The evidence you will hear is that Mr. Piendle got a permanent disability from his Crohn's disease in the 1970s. He had to quit working in 1975, and he never had a job after that. And the Piendles separated for about a year, maybe a little more, in the late 1970s. In fact, Mrs. Piendle went so far as to file for divorce. But once the Piendles got down to Florida, Mr. Piendle, despite his disability, built their house, did some cabinet work for friends, and had an active social life, which included riding motorcycles, which the Piendles did avidly for a number of years. Mr. Piendle was the kind of man who did what he enjoyed. even though he knew there were risks. Just as Mr. Piendle started smoking when friends and family and others around him were smoking, the evidence will be that after many of his friends and siblings and relatives had quit smoking, Charlie Piendle decided to quit smoking too, and that was in 1989. By that time, his mom, his sister, his best friend, Lucille Warbell, or at least among his best friends, her husband, Charles Hamill, we talked about, and finally, they had all quit smoking. And finally, Mr. Piendle decided to join them. And he didn't tell Mrs. Piendle that he was going to quit. He didn't tell Mrs. Piendle he had quit. She found out maybe a couple of days later when she noticed that he wasn't smoking anymore. And you'll learn that Mrs. Piendle was upset with Mr. Piendle for quitting smoking. And it was because she thought they ought to quit together. But Mr. Piendle, you will learn, said, "This is something I had to do by myself. I had to do it on my own." And he did. When he quit in 1989, Mr. Piendle didn't go to any smoking cessation clinic. You will learn that he didn't use nicotine gum, which certainly was available at least by prescription at that time. He didn't go to hypnosis. He didn't do anything like that. He just quit. Cold turkey. He started chewing on the straws and the toothpicks. And he quit even though Mrs. Piendle, as you heard from Mr. Barnhart, and as the evidence will show, was still smoking around him. Mrs. Piendle didn't try to quit smoking in 1989, and I think the evidence will be she quit smoking in about 1999, 3 years after Mr. Piendle had passed away. Despite the fact that Mrs. Piendle was still smoking around him in 1989, Mr. Piendle put down his cigarettes and never picked them up again. Now, something else I wanted to point out about that quit attempt, and it relates to the question of addiction. Mrs. Piendle, the person who knew her husband best, will testify that she didn't really notice that much different about Mr. Piendle when he quit, except for two things. One was he was a little moody, at least for a while, and he'd leave the room when she lit up in front of him. He did that for a while, too. But the evidence will be that Mr. Piendle did not experience most of the withdrawal symptoms that truly addicted smokers experience when they quit. And I think Mr. Barnhart had a demonstrative with some of those up there on the board. He wasn't restless. He didn't have difficulty concentrating. He didn't have trouble sleeping. He didn't get depressed. There wasn't a lot of weight gain. None of that. Okay. That is my summary of the evidence that I expect you will hear about Mr. Piendle and his smoking and the decisions he made. Now I want to talk about how that evidence, some of the other evidence you're going to hear, relates to the questions you'll be asked to decide in this case. Let's talk about that. And I've sort of grouped the questions into a couple of categories. The first one is single class membership. Two issues: addiction and addiction causation. Okay? Was Mr. Piendle addicted? And if so, did his addiction, was it a legal cause? Did it cause his death? All right. The fact that addiction and addiction causation are two different issues might seem a little confusing. And I wanted to say that there's a reason it's a different question. Addiction, you will learn, does not mean that a smoker cannot quit. Even heavily addicted smokers can quit. Now, the findings that Her Honor read to you don't address these threshold issues really at all. And so the jury, in fact, that made those findings initially did not even hear Mr. Piendle's name during the course of the trial, let alone anything to do about his smoking history. So I'm going to wait and talk about the findings until we get to an issue to which they pertain, not the threshold issues of addiction and addiction causation. All right. So, first question, was Mr. Piendle addicted? And I submit the evidence will be no, and I've already talked about some of that evidence, but here's some more. You will learn that no doctor, and remember, Mr. Piendle saw a fair number of doctors because of his Crohn's disease. No doctor ever diagnosed Mr. Piendle as addicted to or dependent upon cigarettes or nicotine. No doctor ever treated Mr. Piendle for addiction to cigarettes or to nicotine. There would be no evidence that Mr. Piendle asked his doctors for help in quitting. According to Mrs. Piendle, Mr. Piendle never said, I'm addicted to cigarettes, I'm addicted to nicotine, I can't quit. The evidence will be that Mr. Piendle was able to refrain from smoking in church, yes, in movies, yes, didn't mention those, in restaurants, after smoking restrictions went into place, yes, at breaks during Tracy Piendle's school events, or when the event was over, he would go outside and smoke. But it's not like he couldn't sit through it. And I wanted to say we use the term addiction these days to describe just about everything, from watching TV and to eating particular foods. But addiction has a medical definition. And the evidence will be that Mr. Piendle did not meet the criteria for diagnosing somebody as addicted that had been established by the American Psychiatric Association. And so, for example, I told you what the evidence will be about the absence of significant withdrawal symptoms that he experienced. That is one of the criteria used to decide whether somebody is addicted medically under the definition used by the American Psychiatric Association. So, in short, you will learn that for the entire time that he smoked, at least prior to 1989, Mr. Piendle never made a memorable and significant attempt to quit until 1989 when he did it. And when he really decided to quit, that's what he did. Use your common sense and ask yourself as you hear the evidence, was Mr. Piendle addicted? Now, the evidence will not be that Mr. Piendle was what I sometimes refer to as a tormented smoker, somebody who hates their smoking, loathes it, who makes serious quit attempt after serious quit attempt, gets assistance, tells their friends and families, and still doesn't quit. That's not who he was. You'll learn that he was the kind of man who you would expect would want to make a career out of the Marines. You'll learn that he was intelligent. You will learn that Mr. Piendle was not gullible. You will learn that he was strong-willed. You will learn, and everybody, I think, will say this, that once he made up his mind to do something, he did it. He was a disciplined Marine, and once he decided to quit for himself, he just put him down, and he never picked him back up. And that's important. Why? It's important because if you nonetheless decide that Mr. Piendle was addicted, then you'll have to decide the other threshold issue, addiction causation. But for his addiction, would Mr. Piendle have gotten lung cancer? In other words, did addiction control Mr. Piendle, or did Mr. Piendle control his smoking? Okay. Now, the experts you'll hear from agree. Even addicted smokers can quit. As you will learn, the Surgeon General of the United States has described cigarette smoking as a personal choice behavior, notwithstanding addiction. Everybody can quit. And many of you know people who have quit. Some of you have quit. And as we learned during the jury selection process, a lot of people have quit smoking. You will learn that there are more former smokers in this country alive today than there are people who currently smoke. There are approximately 50 to 60 million former smokers alive in this country today. And by the criteria of the plaintiff's experts who will come in and testify, the vast majority of those former smokers were addicted, even though a high percentage of them quit without any assistance, cold turkey, just like Mr. Piendle did. And there won't be any dispute in this case about whether or not Mr. Piendle could quit. After all, he did on his own, as he wanted to do. Since Mr. Piendle did quit in 1989, ask yourself this question as you hear the evidence. Why couldn't he have quit in 1979, in 1969, or in 1959? The fact is that more and more of Mr. Piendle's friends and relatives had quit smoking, and they urged him to do it too. His sister did it, his best friend did it, other friends and relatives had quit, and a number of them came to Mr. Piendle and said, you ought to quit too. And so one day he decided he would, and he did. Okay, now I mentioned this before, just want to mention it again. After a smoker quits, their excess risk of lung cancer goes down, That's the increase in risk that smokers have for lung cancer over and above the risk that somebody who's never smoked has. Even never smokers get lung cancer sometimes, a lot less often than smokers. And so that excess risk that a smoker has for lung cancer starts to go down after they quit smoking. And the evidence will be that if Mr. Piendle had quit in 1979, in 1969, in 1959, he probably wouldn't have gotten lung cancer. The evidence on this issue will be that Mr. Piendle controlled his smoking. It did not control him. He wasn't one of those tormented smokers I referred to. Mr. Piendle, you will learn, as everybody will describe him, was not a hapless victim. That's not who the guy was. He was a willing smoker, just as he had willingly enlisted in the Marines and willingly ran around on a big Harley. He did what he wanted to do, and he did it on his own timetable. All right. The next big issue is whether or not the conduct of the defendants described in the findings that you've had read to you and you've seen during the jury selection process was a legal cause of Mr. Piendle's death. And you only get to this issue if you find a plaintiff on the threshold issues. Okay. If you do, as the judge has told you, the findings become relevant. In fact, they become more than relevant. They become binding. And we all have to follow them. And, I'm not here at this podium to tell you that R.J. Reynolds never did anything wrong, and I don't imagine that Mr. Kelly is here to tell you that Philip Morris never did anything wrong. So, like you, if we get to the point where Mr. Piendle is determined to be a member of the Engle class, everybody accepts the findings for purposes of this case. The most important thing to keep in mind about the findings, however, is what Her Honor has already told you. I don't know if I can put this up now, you can actually see it, maybe I'll just hold it. And that is, I can't read it and hold it at the same time, but it is basically that the findings in and of themselves are not enough to find that Reynolds and Philip Morris are liable, that plaintiff is entitled to win this case. And that to prevail, plaintiff has to show that the misconduct of Reynolds and Philip Morris described in those findings was a legal cause. Caused Mr. Piendle to smoke and to get lung cancer and to die. Now the other jury that made those findings, the Engle jury, didn't know Mr. Piendle. They didn't hear any evidence about him. During the course of this trial, you will come to know Mr. Piendle as best as we can, since he's not here. You will know the facts of his life, the information he had, and the decisions he made. Plaintiff's burden is to prove legal cause. Okay? And for each finding, plaintiff has got to prove, by the greater weight of the evidence, that but for the defendant's conduct, Mr. Piendle would not have gotten lung cancer and died. That's their burden, her burden. And I'd like to make a little analogy. It works for me, it may not work for you, and if it doesn't, I'm sorry. But I like to think of the findings on one hand and Mr. Piendle on the other in his decisions about smoking. And what plaintiffs have to do is they have to build a bridge. They have to connect the two. The findings about the conduct of Reynolds and Philip Morris on the one hand, and Mr. Piendle and his smoking decisions on the other. Now, in the real world, bridges are made of steel and concrete. But here, in this courtroom, they're made of evidence. And so, plaintiff will have to produce proof, for example, that Mr. Piendle relied on something that Reynolds or Philip Morris did. Proof that defendant's wrongful conduct, not just the manufacture, marketing, and sale of cigarettes, which again is legal, their wrongful conduct caused Mr. Piendle to get lung cancer. Proof that Reynolds and Philip Morris, not Mr. Piendle, are responsible for the choices that Mr. Piendle made regarding his smoking. And at the end of the trial, should you find that Mr. Piendle was a member of the Engle class, you will have to decide whether or not plaintiff built that bridge with the evidence that she has presented in this courtroom. And I want to talk about that with respect to the findings, and I want to just kind of put them in groups. So we'll talk about concealment, we'll talk about unreasonably dangerous and defective cigarettes, and we'll talk about negligence. I'm just going to talk about those three groups, okay? So let's start with concealment, and whether or not any concealment of information about the health risks of smoking or addiction caused Mr. Piendle to start smoking or kept him from quitting. And we've reviewed some of this. We've reviewed the evidence that way back in high school, at the time he either first started smoking or was only smoking once in a while, hiding from his football coach, Mr. Piendle knew that cigarette smoking caused cancer and death. The cancer sticks in coffin nails, the classes at school, the news, Tex Williams, Mark Twain, and so forth. Okay. If that's what he knew in high school, ask yourself, how will plaintiff prove concealment about the health risks of smoking or addiction could have mattered to him? And later on, the information about that he had and that he knew, and certainly that was available to him, about the health risks of smoking and how hard it can be to quit, only increased. You know, you've got the doctors in 1962, starting with the Crohn's disease, the Surgeon General's report in 64, the warning starting in 66, and so forth. Okay. And you'll have to ask yourself this question. Did Mr. Piendle continue smoking because he did not know about the health risks of smoking or that it could be hard to quit? And you'll hear additional evidence, stuff we haven't talked about yet, that suggests that Mr. Piendle started and willingly continued to smoke for reasons that don't have anything to do about concealment of information concerning the health risks of smoking or addiction. There will be no evidence, for example, that Mr. Piendle saw or heard a specific statement by any of the tobacco companies to the effect that it hasn't been proven that smoking causes lung cancer or more research is needed. There will be no evidence that Mr. Piendle, who after all called his cigarettes cancer sticks in high school, ever relied on anything the tobacco industry ever said or did not say about the health risks of smoking. And apart from the evidence of Mr. Piendle's own knowledge of the health risks of smoking, nobody will say that when Mr. Piendle visited his easy for me to say, hang on, my mouth's getting dry, that's why I'm stumbling over my words. Nobody will come in here and say that when Mr. Piendle visited his doctors, when he was urged to quit smoking by his friends and family members, when he talked to his kids about smoking, that Mr. Piendle ever said anything like, what do you mean I should quit? That Mr. Piendle ever turned around and said to anybody, hey, the tobacco industry says it's not proven that smoking causes lung cancer. The tobacco industry says smoking isn't addictive. There will be no evidence that Mr. Piendle ever responded to suggestions that he quit smoking by playing back some of the public statements of the tobacco industry, whether he knew that that's where they came from or not. He never said, hey, it hasn't been proven smoking causes lung cancer. He never said, it hasn't been proven that smoking is addictive. No, there will be no evidence that Mr. Piendle forgot about the teachers, the doctors, the Surgeon Generals, the warnings on the pack, the American Cancer Society. There will be no evidence that Reynolds and Philip Morris, by their conduct, caused Mr. Piendle to start or to continue to smoke. Maybe there is a smoker who did rely on tobacco company statements, but the evidence in this case will be that Mr. Piendle was not one of them. And as you hear that evidence that plaintiff puts on, ask yourself this. Does it make sense to say what Mr. Piendle already knew didn't matter?
Does it make sense? This is a...
Use your common sense.
No, it's the same. Let the jury know what the evidence will show.
Use your common sense and think about the evidence. Think about what Mr. Piendle, what the evidence shows he knew, and the other information was available, and ask yourself whether it makes any sense to say that, whoa, if R.J. Reynolds Tobacco Company or Philip Morris had said smoking causes lung cancer, it would have made all the difference in the world. The Surgeon General wasn't good enough, the doctors weren't good enough, etc. All right, a word or two about company statements and documents. I want to make 2 points. Again, neither I nor Mr. Kelly are here to tell you that statements by the tobacco industry that it's not proven that smoking causes lung cancer, or that more research was needed, were the tobacco industry's finest hour. It wasn't. But it may surprise you when you learn that scientists and doctors debated about whether smoking causes lung cancer And that includes scientists from the National Cancer Institute and the American Medical Association and universities around this country. And the debate wasn't about what the evidence was. The debate was about what the evidence meant. The debate was about what do you have to show in order to show that smoking causes, another cause word, causes lung cancer. Now, that debate might seem kind of silly to us now, but you'll learn that in the first part of the last century, doctors are really kind of focused mainly on infectious diseases. Identify the bacteria or the virus that causes a specific disease, take it out of the sick animal, put it in a healthy animal, and the healthy animal gets the disease too, cause. And that's the way they were used to thinking about diseases. Lung cancer isn't like that. Lung cancer isn't like that. It's a chronic disease. Many things can cause it. And so there was this debate about whether the evidence that had been assembled was sufficient to say smoking causes lung cancer. Nobody disagreed that smokers got more lung cancer than people who didn't smoke, for example. That wasn't the fight. The fight was about whether or not you could conclude cause. And you will learn that that is a big reason we had a Surgeon General's report in 1964. The reason was they wanted to resolve this debate about how to prove cause, and you will learn that the authors of the 1964 Surgeon General's report argued about it themselves. Now, I wanted to make the second point about tobacco company statements that about nicotine and whether or not nicotine was addictive and denials of that. Neither Reynolds nor Philip Morris, you will learn, or any other member of the tobacco industry ever denied that quitting smoking can be hard. That wasn't the issue. There wasn't any dispute either, you will learn, that nicotine is naturally found in tobacco. There's no dispute, or there will be no dispute during the course of this trial, that nicotine is a very important reason why people smoke. No dispute about that. And there won't be any dispute that nicotine has effects in the brain. All of that, the evidence will show, has been known for a very long time. What changed? What changed? You will learn that what changed was the definition of addiction and whether or not smoking should be labeled as an addiction. You will learn that in 1964, for example, the Surgeon General of the United States, recognizing that smoking can be hard to quit, recognizing that nicotine was an important reason why people smoke, and recognizing that nicotine had effect on nicotinic receptors in the brain, nonetheless concluded smoking is an habituation, not an addiction. And in order to do that, in the 1964 Surgeon General's report, they used the classic definition of addiction. Now, I noticed that in Mr. Barnhart's opening statement, he talked about an internal company document that used the word habituation, and he said, aha, they knew it was addictive. And I understand that, because for years there really wasn't much of a dispute. There was raging agreement about the basic facts, and people used different terms, notwithstanding the Surgeon General's determination in 1964 that smoking was an habituation instead of an addiction. People were sloppy. They used different words. Some people called it a habit. Some people called it an habituation. Some people, you will learn, called it a dependence, and some people called it an addiction. Okay? But then, in 1988, 1 year before Charlie Piendle quit smoking, in 1988, you will learn that the Surgeon General of the United States changed the definition of addiction. And so, no longer did the Surgeon General's definition require that there be severe or life-threatening withdrawal effects when somebody quits a substance in order for it to be labeled an addiction. So, for example, alcoholics can get the DTs. People withdrawing from heroin can die. That doesn't happen to people who quit smoking cigarettes. All right. Second thing that changed. No longer did the Surgeon General's definition require, in order to label something an addiction, that it be intoxicating, that it interfere with your ability to go about your daily life. Okay. Third, you will learn, the Surgeon General dropped the requirement in 1988 that an addiction be associated with socially deviant behavior. And as a consequence of that 1988 change in definition, smoking, like heroin, like alcohol, was declared an addiction. Now, the tobacco industry, you will learn, resisted the 1988 change in definition that slapped the same label on cigarette smoking as on heroin, an addiction. And that's when a dispute over how to label smoking became news, and that is when the tobacco industry began to vigorously deny that nicotine was addictive. It was a dispute arising about 1988 about definitions and labels. The behavior hadn't changed one bit, and there really wasn't an argument about what that behavior was. Plaintiff will not prove that tobacco industry statements that it hasn't been proven that nicotine is addicting caused Mr. Piendle to start. That dispute didn't really arise until very, very late, and certainly didn't keep him from quitting between 1988 and 1989. Okay. Next finding, that we're done with concealment. Now let's talk about defective and unreasonably dangerous products. The evidence you will hear during the course of this trial is that no cigarette is safe. It cannot be done. All tobacco-burning cigarettes cause lung cancer. Can't be avoided. What evidence, ask yourself as you listen to the evidence, what made the cigarettes principally smoked by Mr. Piendle, Marlboro, Winston, Raleigh, Durrell, and Merritt, defective and unreasonably dangerous? The findings don't tell you. Plaintiff nonetheless has to prove that that Mr. Piendle smoked defectively and unreasonably dangerous cigarettes that caused him to get lung cancer. And I want to make 2 points about that. First point is this. The evidence will be that Reynolds and Philip Morris tried just about everything in an attempt to make cigarettes safer or less hazardous, recognizing that they could not be made safe. They worked, for example, for many years, you will hear, with the National Cancer Institute in its less hazardous cigarette program until the government essentially gave up during the Carter administration. And then they continued to do the work on their own. You will learn that Reynolds and Philip Morris tried to remove individual compounds found in cigarette smoke that were thought to be harmful, and that it's really hard to do. You will learn that there's about 4,000 chemicals or more in cigarette smoke, and it's all moving down that cigarette rod, and it's changing as it gets heated and cooled, and so the chemicals keep changing, and it's really hard to reach into that stew and to grab 1 or 2 or 40 or however many compounds you think are hazardous to health and pull them out before they can get delivered to a smoker. There were some successes, but mostly not. That effort to remove individual compounds from cigarette smoke mainly failed. There were some successes, and those successes are in commercial cigarettes. You will learn that cigarettes that were made that contain no or virtually no nicotine. Philip Morris, for example, made a no or virtually no nicotine cigarette called Next. And those kinds of cigarettes have been around going back even before the 1964 Surgeon General's report, because the report commented on them. And the problem has always been the same. Virtually nobody buys them, including Mr. Piendle. The cigarettes without nicotine are commercial failures. They are the tobacco industry's new hope. All right. You will learn that Reynolds and Philip Morris reduced tar and nicotine levels in cigarettes. And when the tar and nicotine yields got to be so low that most smokers wouldn't buy them anymore, it was like smoking through a mattress. When they wouldn't buy them anymore, they said, what are we going to do now? And they started to develop products in the 1980s that heated tobacco instead of burning it. And when you heat tobacco, you can volatilize the nicotine, you can volatilize flavorants off of the tobacco, but you don't produce conventional tar that comes from actually burning it. And you will learn that it is the tar in cigarette smoke that causes cancer. So the public health community looked at this and they said, hey, maybe an idea would be, let's reduce the tar to keep the nicotine levels the same or maybe even higher, so that smokers can get nicotine, which is primarily why most smokers smoke, but avoid the tar and reduce their health risks. And you will learn that Reynolds and Philip Morris tried to do that in the laboratory. But the idea never got incorporated into commercial cigarettes. And the reason is they couldn't get them to taste good. Couldn't get them to be acceptable to the consumer. In short, the evidence that you will hear is that for the last half century or more, Reynolds and Philip Morris have tried to make cigarettes less risky. Here's my second point. The evidence, as I think I've already suggested, will be that Mr. Piendle smoked whatever Mrs. Piendle bought, based on taste and sometimes price. The evidence will be that the Piendles did not smoke those brands of cigarettes that at various times the public health community has thought might be safer. For example, there was no evidence that the Piendles ever smoked as their regular brand a carbon-filtered cigarette. There was carbon-filtered cigarettes, many of them on the market in the 1960s at the time when that was thought to pose some health advantage over cigarettes that did not have that kind of filter. There will be no evidence that the Piendles ever chose as their regular brands the lowest of the ultra-low tar and nicotine cigarettes, brands like R.J. Reynolds Tobacco Company's Now or Carlton, 1 milligram of tar. There will be no evidence that the Piendles ever tried a cigarette that had no nicotine or very low levels of nicotine, such as Philip Morris's next cigarette. And the evidence will be that taste and to a lesser extent price, but not safety, were the biggest factors in determining what brands of cigarettes Mrs. Piendle bought and what Mr. Piendle smoked. Okay, just quickly on the last finding I want to talk about, which is negligence. And again, the finding doesn't tell you what the negligent conduct was or when it occurred. Again, plaintiff will have to prove that the negligence of R.J. Reynolds and Philip Morris was a legal cause. But for that conduct, Mr. Piendle would not have gotten lung cancer. And I would suggest to you that the evidence will be that they will not carry that proof. I kind of wanted to wrap up this section by saying that at the end of the day, plaintiffs won't be able to build that bridge with evidence that I talked about between the findings, the wrongful past conduct of R.J. Reynolds and Philip Morris on the one hand, and Mr. Piendle's smoking decisions on the other hand. And you will learn that Mrs. Piendle said as much in her prior testimony in this case. She was asked, whether or not, or she was asked why, rather, she blames the tobacco companies for Mr. Piendle's death. And her answer was, they make the product. And the next question was, any other reason? I can't think of any other. But making the product alone is a legal activity. It is not wrongful conduct. And Mrs. Piendle also doesn't think she bears any responsibility for Mr. Piendle's death. She was asked. She said no. The next question was, why not? And her answer was, he was an adult. He could make his own decisions. Sound familiar? All right, let's talk about the next issue, which is responsibility or fault. If you decide that some wrongful conduct, those findings, caused Mr. Piendle to get lung cancer, they build the bridge, then you will have to assess fault. And as you hear that evidence, I want you to think and ask yourself, who had the best opportunity to avoid the tragedy of Mr. Piendle's death? And I submit the evidence will be that it was Mr. Piendle. Plaintiff admits that Mr. Piendle was at fault, and that's true even if you find that he was addicted, because remember, even addicted smokers can quit, and he did. It will be undisputed that Mr. Piendle was not addicted when he tried his first cigarette, hiding from authority figures like the football coach, and after he'd had the classes about smoking and health in school. Even plaintiff's experts will agree that there was a period of time after that first cigarette when Mr. Piendle was not addicted. And when he was starting, or only once in a while in high school, he knew again that cigarettes could cause cancer and death. Remember, cancer sticks and coffin nails. And even if you find, as Mr. Scarola said during jury selection, that Mr. Piendle was a nicotine-using addict later in life, Mr. Piendle still knew that smoking caused cancer and death, and the evidence will be that he could quit, but he didn't until 1989, and unfortunately, that was too late for him. Then there is the question of the responsibility or fault of the defendants, R.J. Reynolds and Philip Morris. And I will admit, like any other organization or even family, R.J. Reynolds Tobacco Company made some decisions that were mistakes, especially when they are viewed from our perspective today with the benefit of 20/20 hindsight. And I will also admit that when you see some of the memos and the documents from the file of my client or from other members of the tobacco industry, remember Reynolds probably had tens of thousands of employees going back to the 1950s, half century or more. You'll see that some of those ideas expressed in those memos weren't very good. And you will also see that some of those ideas were just downright stupid. Okay. And Plaintiff has got a greatest hit list of those documents out of all of the millions of documents that are available. Millions of them. And I ask you to be fair. I ask you, when you see those documents, to look at the big picture. I ask that you ask yourself some questions. Was this company policy? You know, was the idea ever actually implemented? What does this have to do with Mr. Piendle's decisions to start or to continue smoking? Is this part of the bridge? What difference do the documents have made to Mr. Piendle? And if, based on all the evidence, you nonetheless decide that the plaintiff has met her burden of proving that the defendants did something wrong, findings, not just selling cigarettes, that caused, legal cause, they've got to prove that caused Mr. Piendle to get lung cancer and die, then you will have to determine the responsibility of Reynolds and Philip Morris. And in view of the evidence you will hear about Mr. Piendle's disregard of the information he knew or that was readily available to him about the health risks of smoking, the evidence will be that Reynolds and Philip Morris should bear no, or at most only a very small portion of responsibility. I wanted to talk a little bit about punitive damages. As Her Honor has told you, the plaintiff must show that the wrongful conduct of the defendants, if any, that caused Mr. Piendle to get lung cancer amounted to reckless disregard, conscious indifference, or intentional violations of Mr. Piendle's rights. And they've got to make that showing by an even higher burden, clear and convincing evidence, not just the greater weight of the evidence. I've already talked about some of the evidence that bears on that question, but there will be more. You will hear about the measures that my client, R.J. Reynolds, has made to address past conduct. You will learn that R.J. Reynolds Tobacco Company publicly acknowledges that smoking causes lung cancer and other diseases, and it has done so for a decade or more. I have also done that in this trial, and I will continue to do so. You will learn that R.J. Reynolds Tobacco Company says nicotine is addictive, again, for 10 years or more. You will learn that R.J. Reynolds Tobacco makes a legal product, and it always has. You will learn about the intense research and development efforts at R.J. Reynolds Tobacco Company that began way back in the 1950s and remain vibrant today to try to make a safer cigarette, recognizing that none of them are safe. You will learn that R.J. Reynolds is committing resources to encourage people who smoke cigarettes to migrate to smokeless tobacco because it's less risky. And so they are investing resources in making smokeless tobacco products and encouraging smokers to switch to them. You will learn that R.J. Reynolds Tobacco Company's sister company hopes to start selling nicotine replacement products in this country to help smokers quit. I ask that you consider the evidence, and when you do, ask yourself whether or not there is any need to punish R.J. Reynolds Tobacco Company to deter it from doing again the kinds of things that gave rise to the findings in this case many years ago. All right, a word about patience, and maybe I've tried your patience already. But the way this trial works, you heard the plaintiff open first. And plaintiff will present her evidence first. You will hear from the plaintiff's witnesses. You will see the plaintiff's exhibits first before the defendant, either one, puts on their first witness or their first exhibit. So, as I think Mr. Kelly said, remember there's a rest of the story. And to be fair judges of the facts in this case, because that is what you are the judges of the facts, Your Honor is the judge of the law, I ask you to wait. Just as those of you who are soccer fans didn't stop watching the World Cup after the first half, just like you don't turn off the baseball game after 2 innings, and just as you usually don't leave a movie unless it's really bad before the end, I ask you to stick with us. Don't leave the movie. Please keep an open mind until all of the evidence is before you. Again, you won't hear the defense evidence or see a defense witness until the plaintiff is done. So look at the whole evidentiary picture, please, before you make judgments. And that whole evidentiary picture will show that plaintiffs will not prove by the greater weight of the evidence that Mr. Piendle was addicted to cigarettes containing nicotine. It will not show that his addiction, as opposed to his choices, caused him to smoke and to get lung cancer. Mr. Piendle was fully capable of quitting earlier than he did. He controlled his smoking. It did not control him. The evidence plaintiffs will not build that bridge between the findings and Mr. Piendle's smoking decision and lung cancer. They will not prove that the findings were a but-for cause of Mr. Piendle's death. Mr. Piendle should bear all or nearly all of the responsibility for his own smoking decisions and ultimately for his lung cancer. And there will be no clear and convincing evidence that any misconduct by the defendants that caused Mr. Piendle's lung cancer and death warrants the imposition of punitive damages. Okay, that concludes my part of opening statement. It's the first part of the trial. As Your Honor has told you, it is not evidence, but it's still important. It's a chance for us, the lawyers, to tell you what we think the evidence will be, and also to help you start thinking about the evidence that you'll be receiving. And I would be remiss if I did not say this. Thank you. Thank you for doing your civic duty. Thank you for your attention and patience. You've been remarkable so far, and I have no doubt in my mind that you will be remarkable through the remainder of this trial. I also know that it is inconvenient, and for some of you, very inconvenient, to be here away from your jobs, away from your families, and away from your daily obligations. It is a sacrifice that everybody in this courtroom deeply appreciates. Thank you very much.
Thank you. Ladies and gentlemen, we'll take a brief recess before Philip Morris's counsel gives opening statement. So we'll be in recess for 15 minutes. I ask that you be back at 5 minutes before.
May it please the court, Your Honor?
Yes.
Counsel, Ms. Piendle, and ladies and gentlemen. I'm going to be talking to you for less than an hour. That's the good news. I'm talking to you once again after two other lawyers have spoken to you about the same subjects that I'm going to talk to you about, and I will do my best to try not to duplicate to a boring extent what's already been told to you about the evidence that you're going to be seeing over the next couple of weeks. I want to join with other counsel and the court in thanking you for the patience you've shown, thanking you for accepting the responsibility to be jurors in this case, to come into the case as neutral, impartial jurors, and to maintain that neutrality for the next couple of weeks as you see the evidence, you hear the witnesses, and you are subjected to the attorneys not being neutral, because we're not supposed to be, but you are. And I thank you for that in advance. What I'm going to be talking to you about initially is what has been called the threshold issue that you'll be addressing, the threshold issue in the case, class membership. It's one issue that has two questions. Was Charles Piendle addicted to cigarettes containing nicotine manufactured by the defendants? Pause. And if so, was such addiction a legal cause of his lung cancer? I've broken it into two questions for you. So I'm going to address first question number one, and the evidence relating to whether Charles Piendle was addicted to cigarettes containing nicotine manufactured by the defendants. And I think we talked about earlier, and you will see evidence and hear evidence from witnesses who will be talking about addiction. And you've learned already that the evidence is going to indicate that various definitions of addiction have been used over time, dating back to the first Surgeon General's report in 1964, where the committee addressed that issue and determined that cigarette smoking was best defined at that time as an habituation, a habit, and not an addiction, as the definition of addiction was used at that time. Then you heard that the Surgeon General changed the definition in 1988 to a different definition with fewer requirements and criteria. That's the second definition you've heard about. You've heard about the definition of addiction used by the American Psychiatric Association, the third definition of addiction that you're going to hear some testimony about in this case. And then you're going to hear from witnesses who have addressed addiction in settings like quit clinics or in medical settings, and they may have their own definitions of addiction that will be submitted to you. For example, you'll hear one of the plaintiff's experts, you saw his picture earlier today, Dr. Michael Cummings. Dr. Cummings has several definitions of addiction that he uses or has used in these kinds of cases. And one of the definitions he uses is that anyone who has smoked 100 cigarettes in a lifetime, whether they're smoking now or they quit 20 years ago after their 100th cigarette, is addicted. Smoke 100 cigarettes and you're addicted for life, according to Dr. Cummings. It's another definition. You'll hear from Dr. Benowitz. Dr. Neil Benowitz from San Francisco, he's a medical doctor. Dr. Cummings is not a medical doctor. He is not licensed or certified to treat or diagnose medical patients, but Dr. Benowitz is. And Dr. Benowitz was hired in this case by the plaintiffs, and he was asked to review Mr. Piendle's medical records and try and reach an assessment, a medical assessment, of whether or not Mr. Piendle was addicted. He reviewed those records, and he determined that according to the American Psychiatric Association's criteria, he could not determine that Mr. Piendle was addicted according to that definition based upon the information that he'd been provided. The defendants are going to ask you to consider on the issue of whether or not Mr. Piendle was addicted, his personal smoking history. And you've heard a lot about his personal smoking history so far. And I'm going to try and just touch upon a few evidentiary points concerning his personal smoking history that may impact the question of whether or not he was addicted. I think you're going to find that Mr. Piendle, when he first started smoking and began smoking regularly as a young adult after he joined the Marines, started with his friends, continued with the Marines, after getting out of the Marines, continued smoking with his friends, was a very social guy, had a lot of friends, and many of those friends smoked. When he was with those friends, he smoked. When he was in situations where you couldn't smoke, like in movies, restaurants, when he went on his long motorcycle rides, he didn't need to smoke. Now, Mr. Piendle was never diagnosed as being addicted to nicotine and cigarettes. He never sought counseling to quit smoking at any time. He never complained to anybody that he was a nicotine-using addict. In fact, Mr. Piendle never complained to anybody about his inability to quit smoking, because the evidence just isn't there that he had an inability to quit smoking. The evidence is that on several occasions, he and his wife, over New Year's, resolved to try and quit or cut down on smoking. The evidence is that they tried to cut down, but you'll hear from the experts, the witnesses, and the evidence you'll receive is that cutting down is not quitting. None of the experts characterizes cutting down smoking as a serious quit attempt. A quit attempt is when you actually quit and commit to quit and are successful for some period of time. When Mr. Piendle and Mrs. Piendle tried to quit together, they were not successful. So in 1989, the evidence will be that the social group that Mr. Piendle had, that peer group that he smoked with, was no longer smoking, by and large. And so he decided in 1989 to join that group, to go along with his friends, to commit to quit, and he quit. And he did it alone. Once he quit in 1989, and he had been quit for several days before his wife even noticed that he'd stopped quitting, he never smoked again. Now, the experts are going to come on and tell you about addicted smokers and all of the experiences that addicted smokers have when they attempt to quit and quit for a while. And they have a number of relapses they'll testify about, and they will have physical discomfort, nausea, sleepless nights, a whole slew of characteristics that are the consequences of quitting smoking when you're addicted, according to the plaintiff's experts. There was a demonstrative the counsel used that I'd like to show Your Honor if I could. It's entitled Relapse Rate. I'll I'll put it on the Elmo if that's all right. Thank you. This is one of the exhibits that the plaintiff's experts intend to talk about. And they intend to indicate that the relapse rate for addicted smokers is 95% or more. The evidence is going to be that Mr. Piendle is in the 5%. He stopped, he committed to quit, he quit, and he did not relapse, despite, as the evidence will show, that his wife continued to smoke in the house for the remainder of his life. He never again picked up a cigarette. This is some of the evidence that you can consider in determining whether he was addicted, the fact that he did not relapse. And the evidence the plaintiffs are going to show you that claims that addicted smokers relapse. Mr. Piendle did not. May I have the computer back, please? Thank you. Let me discuss very briefly the question number 2. And question number 2, I think you all understand at this juncture that question number 1, if you answer that yes, you go to question number 2. If you don't answer it yes, he was not addicted, based upon the evidence you're going to get. And the evidence on that question is Mr. Piendle specific. This is an individual question related to Mr. Piendle, not other people who might be addicted, but Mr. Piendle specifically. Was such addiction a legal cause of his lung cancer? Because as I indicated, there's going to be a bunch of definitions that you might receive, and if there's a broad definition of addiction that has on one end of the spectrum folks who are addicted but it's easy to quit, and on the other end folks who are addicted but it's very hard to quit and they'll relapse, then you might need to take a look at the evidence to see where on the spectrum Mr. Piendle is to determine whether his addiction was so severe, for question number 2, that he lost control over his choice to smoke or to quit. Legal cause in this context is loss of control. And the evidence will be that Mr. Piendle never lost control over his choice to smoke or to quit. He was referred to at some point today with the term weak. The evidence is going to be, in addition to what you've heard so far, that although he was undersized, he was quick, and he was tough, and he played high school football, and ran track, and did gymnastics, and as soon as he could, he joined the Marines. And you'll hear the evidence of his comments to his friends later in his life, that Marines today are a bunch of wusses. And that's how Mr. Piendle felt about being a Marine. Weak, I don't think the evidence will support as being an accurate description of Mr. Piendle when you consider all of the experiences in his life. When Mr. Piendle did quit, I would submit to you that the evidence surrounding that experience is the evidence most relevant to this question of loss of control, legal cause. Because it's only when...
Object, that is not, I hate to do that, counsel, but that is not the legal standard. It's whether it is a contributing cause. That's the legal standard.
Okay, well, I read the jury instructions on legal cause, so why don't we stick with telling the jury what the evidence will show.
Thank you, Your Honor. Looking at his experience when he attempted to quit and did successfully quit when he committed to quit, I would submit to you will show that before he attempted to quit, there was no buildup of emotion or anxiety or concern about quitting. There was no effort before he quit to attend a counseling session or to obtain advice or support from any outside group or even his family. That before he before he committed to quit and successfully quit, he did not go and get any quit assist tools like nicotine replacement products like gum or like patches. Patches may not have been available then. I think in 1989 it may just have been nicotine gum that was available. He did not take advantage, did not feel it was necessary to take advantage of any of those nicotine replacement tools. When he did quit, he never relapsed, as we've talked about, but he also didn't need any of the nicotine replacement tools after he stopped. The only thing he used after he quit to help him stop smoking, toothpicks and gum and straws. And the gum that he used was not the nicotine replacement gum, the Nicorette gum, it was just chewing gum. So he did use a tool. He put something in his mouth to help him quit smoking. But that, I would submit to you, is not evidence of a nicotine-using addiction. The evidence will be from the experts who plaintiffs are going to call that smokers who have trouble controlling their choice to smoke have a difficult time quitting when they are around other smokers and around activities in which they used to smoke. No evidence that that was Mr. Piendle's experience. Despite the fact that Mrs. Piendle continued to smoke in the house and had cigarettes available in the house after Mr. Piendle quit, did not affect his ability to remain quitting. He did not relapse despite the availability right there at home, 24 hours a day, of cigarettes. One of the experts the plaintiff is going to call, Dr. Benowitz, describes a test that he uses sometimes called the Fagerstrom test, Fagerstrom, Fagerstrom test, for the record, Your Honor. And he describes that as a addiction severity test. It's a test by which you can measure the severity of a smoker's addiction. And he reviewed that material that was provided to him by plaintiff's counsel to see whether or not he could conclude that using that test he could characterize the severity of Mr. Piendle's addiction in his view. the information was insufficient for him to apply that test to Mr. Piendle. I've restricted my comments to Mr. Piendle because this case is about Mr. Piendle. By talking about Mr. Piendle's personal experience, I'm not suggesting that other smokers who attempt to quit don't have a hard time. That's not the point I'm making. What I'm asking you to do is look at Mr. Piendle's experience, the individual experience that he had in answering these two questions. I'm going to leave the threshold issue now, and I'm going to address just one other area before I conclude my comments on the evidence. Mr. Bierstacker spent time with you for the last hour or so talking about the requirement that the evidence the plaintiffs present connect the findings to Mr. Piendle's illness and death. I'm not going to touch upon that now. What I'm going to address is the evidence concerning Mrs. Piendle's claim for more money than is necessary to compensate her for the loss that she suffered for punitive damages by way of punishment. And there's a completely different standard for the burden of proof that applies to that issue, as Her Honor has read to you, the clear and convincing standard. The claim is that the companies intended, by their design choices, to harm their customers. And I want to direct the balance of my discussion with you to the evidence.
I object again. That is not the legal standard.
I would abstain insofar as not needing to reference the instructions, as the court has already read that, and just to simply tell the jury what the evidence will show.
Yes, Your Honor. With respect to the claim for punitive damages, the evidence will be that the design changes that Reynolds and Philip Morris put into their cigarettes in the 50s and the 60s and the 70s and on were intended for the purpose of reducing the risk of harm from cigarettes, not increasing it as the plaintiffs claim. I'm going to talk a little bit about cigarettes and what happens when cigarettes are smoked. I put up on the board here a cigarette from the last couple of centuries. For hundreds of years, the cigarette in America was tobacco farmed and cured, chopped up, and rolled in cigarette paper. When that cigarette is lit, and begins to burn, the burning of the organic material creates chemicals by the combustion process of the organic material breaking down, and as the smoke, the vapors are carried through the cigarette to the smoker, along with the smoke are those chemicals. Just like burning a log on a fire or burning the barbecue, when organic material is burned, it breaks down into its component parts and new chemicals are created. The easiest example is carbon material, like a log. In the fire, it breaks down into its base components. One of those is carbon monoxide. The log didn't have carbon monoxide in it when it started burning, but as it burned, the burning process causes that new chemical to be present in the smoke. Similar process with a cigarette. Now, in the 50s, beginning in the 50s, design changes were made to the basic cigarette, and that continued on for years and years. I'm going to talk about some of the basic ones that were part of the cigarette in the 60s and 70s. The basic idea behind all of these design changes is based upon the idea that the harmful compounds in cigarette smoke are in the smoke, and that the less harmful compounds, the better. So in the 50s and the 60s, some of the leading scientists studying the link between smoking and lung cancer recommended that the reduction in the harmful compounds in the smoke would undoubtedly lead to the reduction in harm to the smoker. So let me talk about these basic design features of the cigarette. The filter. It's pretty basic. The filter, whether it's filtering the oil in your car or the water or the air, a filter strains out materials that are passing through. The filters on cigarettes accomplished something very similar, straining out and reducing the compounds in the smoke, not all of them, but reduce them. Some of the designs of the filters over time managed to actually filter out specific harmful compounds, things like phenol, that are in the smoke. But those are later iterations of the filter design. Ventilation is a design feature whereby holes are placed around the filter so that when the smoker inhales, air is sucked in through those holes and combines with the smoke as it passes through the filter, causing the smoke to be diluted. So that's the function of ventilation, and you'll hear maybe a little bit about ventilation from Dr. Ferrone, for example, but the purpose of ventilation is to reduce the smoke by reason of dilution with air that is pulled in to the filter. I'm going to skip down to permeable paper, or porous paper, which is the cigarette paper that tobacco is wrapped in. It's like a finely woven cloth, and what the designers accomplished were means to make the weave looser so that air, in addition to coming in through the ventilation holes, air would come in through the paper. And that reduced some of the other harmful compounds in the smoke. Again, the philosophy, the design intent of less being better. Porous paper increased the air and allowed some of the gases to escape instead of going into the filter. In addition to the design features of the cigarette structure, the internal components, the tobacco itself was modified throughout and for a long period of time. Some of those modifications were things like reconstituted tobacco. Reconstituted tobacco was a process by which parts of the tobacco are made into a paper-like material and then chopped up like tobacco and added to the blend. Scientific tests indicated that reconstituted tobacco were less toxic in some of the tests than other tobacco. Expanded tobacco, another design feature developed by the tobacco companies, and I would say that, point out that the evidence is going to be all of these features were designed, created, developed by various of the tobacco companies, including Reynolds and Philip Morris, and Reynolds and Philip Morris incorporated these design features as they became available into their products. Expanded tobacco is tobacco that is puffed up through a process of various kinds used by the companies. Philip Morris used one called Diet that Dr. Ferrone had a hand in helping out with. And what it does is it puffs up the tobacco so that there is less tobacco filling up the space by weight. So less is being burned. So expanded tobacco, when burned, reduces the smoke by taking up more space in the tobacco tube. So those are four basic engineering techniques, design changes that the tobacco companies use for the purpose of trying to reduce the risk of smoking. None of these features make cigarettes safe. The idea was to reduce the risk. Less is better. Like standing out in the sun, if you stand out in the sun long enough and you have enough exposure, you will be harmed. Reducing your exposure reduces your harm. The same basic concept that the scientists recommended in the 50s and 60s that brought about these design features. Mr. Bierstecker mentioned the Tobacco Working Group. The Tobacco Working Group was put together following the Surgeon General's report in 1964, in 1968, and it involved members from the government, health agencies, from the tobacco industry as consultants, and independent scientists and researchers who have been working in the areas of smoking and health to accomplish as their principal goal, their only goal, to design a less hazardous cigarette. They were together for 10 years, 1968 to 1978, when the government disbanded the group. The recommendations that they made, based upon their research, were for the design features: filtration, ventilation, reconstituted tobacco, expanded tobacco, and permeable paper that the companies had developed and created and had put in place. Sorry, Your Honor, I'm out of control on what you're doing. All right. The graph indicating historically from the 50s through the 90s the results of those design changes as measured by the standardized FTC smoking machines, not as people, but the standardized FTC machines required by the government, based upon the porous paper, the reconstituted tobacco, the filters, the ventilation, and the expanded tobacco. And you can see that the effort to reduce tar was successful over time. That is not to suggest that those cigarettes are safe or safer, but to indicate to you the effort that the industry made to follow the design philosophy of less being better that had been set out. And I'm just putting up here on the next slide the products that Philip Morris had on the market that reflected the design changes to various degrees. The design features as they're used in products, depending upon how you use them, you can reduce, as measured by the FTC method, the tar and nicotine measurements in the various products. All of these products were available out in the marketplace for smokers if they chose a reduced tar and nicotine product. I'm not sure we're going to get Dr. Ferrone very clearly on the screen, but Dr. Ferrone, William Ferrone, is one of the witnesses that the plaintiffs have hired in this case to come in and testify to you. For a period of time, from 1976 to 1984, Dr. Ferrone was an employee of Philip Morris, working in the research and development department at Philip Morris. Now, Dr. Ferrone, and he'll testify by videotape in this case, I understand. Dr. Ferrone was with the company for, as I said, about 8 years before he was denied a promotion that he felt he was entitled to, and he threatened to sue the company, and he was let go in 1984. While he was with the company, he had a number of positions in the research and development activity and was involved with a lot of the design activities and design features I've just shown you. He's going to be testifying about people he knew at the company, and he has some unkind things to say about some of the people at the company, based upon his recollection. But he also has things to say about the people that he worked with at the company who worked with him on the projects in the research and development activity that involved the effort to make a safer cigarette at Philip Morris. And I want to tell you a little bit about that testimony in the time that I have left this afternoon. Dr. Ferrone will testify, I believe, that when he joined Philip Morris in 1976, the people who he worked with in research and development were dedicated to the task of making a safer cigarette and cared about their customers. Like in any large organization, there were what he would call problem people. By and large, the caliber of the people he worked with, in his opinion, was excellent. In the 1960s, when the Surgeon General's Committee was formed, one of the things you will hear in the evidence that Philip Morris did as part of that committee's investigation was to provide the committee with some of its research into the chemical compounds of cigarettes and the harmful compounds in cigarettes that it had identified in the research. It put that together in a publication and provided it to the Surgeon General's Committee for the work that they were doing investigating the link between smoking and lung cancer. The Surgeon General, in response, thanked Philip Morris for the information provided. Reynolds submitted similar information and received similar thanks from the Surgeon General. Dr. Ferrone will testify that when the Surgeon General's committee was investigating the link between smoking and cancer in 1963, Philip Morris provided the Surgeon General committee with a list of those harmful ingredients in cigarette smoke that it had identified from reviewing the scientific literature. The Surgeon General thanked PM for its submission, as the Surgeon General also thanked other tobacco companies, including Reynolds. Dr. Ferrone agrees that providing that information to the Surgeon General Committee was the right thing to do, a good thing to do. Dr. Ferrone will testify with respect to the design features that I've very generally described to you, that filters, porous paper, ventilation, expanded tobacco, reconstituted tobacco were good ideas intended to reduce the harm from smoking. There's no question but that the introduction of these design features reduced the risk from those designs that were in place before with unfiltered cigarettes. Dr. Ferrone worked in the research and development activity. He worked in applied research for most of his time there, but the research and development department was much larger than just the area he worked in. He'll testify that when he joined the company in 1976, over 80% of the 400 employees in the research and development department were committed to making a safer cigarette. During his years at Philip Morris, the number of people just in research and development who were working toward making a safer cigarette increased by half. The risk reduction work that he and those other employees were involved in his opinion, was in the best interests of Philip Morris's customers and the public health in general, and he was proud of that work. Dr. Ferrone will describe in his testimony, perhaps, the work he did on projects to reduce tar and nicotine in cigarette products. While he was with the company, Philip Morris developed 2 brands of cigarettes that had reduced tar and nicotine levels down to virtually nothing. Bottom end of our spectrum there, you saw the Merit. There was actually one that's even lower that was called Cambridge. As counsel indicated, nicotine in cigarettes was an issue that was investigated by the research and development activities and independent scientists for many, many years. Philip Morris, in an effort to develop a denicotinized cigarette, actually bought a process for making decaffeinated coffee to use that with tobacco, and designed and developed a plant which would produce denicotinized cigarettes. Produced them, marketed them, and sold them. Not only were they not bought by any customers, the public health community and the anti-smoking community at that time, and even popular publications, criticized taking the nicotine out of the cigarettes and selling cigarettes, according to Dr. Ferrone. I've described very briefly the chemical process that occurs when you burn tobacco or organic material, and it occurred to a number of companies that if cigarettes could be made that didn't burn the tobacco, but just heated it to the point of combustion, but not to combustion, that the risk could be reduced. Reynolds and Philip Morris designed such a product and actually put it on the market. Dr. Ferrone will testify that those products actually reduced many of the harmful chemicals that are created when tobacco is burned, because this tobacco is only heated. But the anti-smoking and public health communities demanded that the product be removed from the market, according to Dr. Ferrone. You have heard some discussion about additives and ingredients. Dr. Ferrone will testify that if you were to take just tobacco from the farm, from the curing barns on the farm, chop it up, roll it up in cigarette paper, and don't put any additives or ingredients in it at all, and light that cigarette, you will have all of the same harmful compounds as a cigarette that had additives and ingredients in it. That additives and ingredients do not increase the risk of harm to a smoker. There are additive-free cigarettes. Dr. Ferrone confirms that the public health community has uniformly said that cigarettes without additives are no safer than cigarettes with additives, and he agrees with that. Oops. Can I have the computer back, please? Thank you. There's a lot of talk about nicotine. This picture is tobacco growing in a field with a picture of a nicotine tobacco plant with the name, the Latin name on it, Nicotiana tobacco. Nicotine is in the tobacco leaf. It's in the name of the tobacco. When you grow tobacco, nicotine is formed and is contained in the leaf of the tobacco. Dr. Ferrone was asked whether or not Philip Morris ever spiked its cigarettes with nicotine. He answered, no. In fact, the testimony will be that from the time the tobacco is picked from the field and sent off for curing and eventually makes its way to the factory and is processed into a cigarette, it has less nicotine at the end of that process than when it came out of the field. Nicotine is a volatile substance, and not sure exactly what the right term is, evaporates over time. So that at the end of the process of making a cigarette, there's actually less nicotine than at the beginning. That's what the evidence will be, and Dr. Ferrone confirms that. Dr. Ferrone will testify that the percentage of nicotine in tobacco naturally goes down throughout the entire process of processing of tobacco, from where it's cut in the field to where the cigarette goes out the door. You're going to hear a lot more about cigarettes and design from Dr. Ferrone, but the evidence that Dr. Ferrone will testify about, based upon his experience at Philip Morris during the period of time, partly when Mr. Piendle smoked Philip Morris products, was that the activities of the company were directed toward designing a safer cigarette. And the features that he'll talk about were all directed toward that purpose, that goal, and more importantly, with that intent. Because this punitive claim that is on the tail end of this case really is about intent. What did the companies intend with their design? Dr. Ferrone, even though he's no friend of the company, testifying here paid by the plaintiffs, when he's under oath will concede these things, I believe. The last subject I want to talk about before I conclude has to do with documents, and as counsel indicated, There are millions and millions of documents that the companies have made available over the years. You have seen just a few. You have heard about just a few, if I might say it that way. You have heard about just a few, and you will see just a few. You have heard about clips, excerpts from some of the documents. Now, I'm not going to say that there aren't some rotten apples among all the barrels of documents that are available. You will see some of those as well. What I'm asking is that you take a look at the evidence and not assume that all the apples are rotten because some of them are. And to look at the entire document before deciding what the document means or says. I'll give you I think I can give you maybe 2 examples of what the evidence is going to show from what you've heard already. I can't cover all of them. I don't have time. But there was a document that referenced psychological crutch. And psychological crutch was used by plaintiff's counsel as if it were a marketing technique that the company used for years and years and years and years and years. The truth is, the evidence is, that's argumentative, I apologize, counsel. The evidence is that, I got all the way through without, all right. The evidence will be this. In 1964, the Surgeon General Committee issued its report. And in response to that report, people at Philip Morris read the report and issued memos giving their 2 cents about what they think the report meant and what the company should do. The term psychological crutch was contained in the Surgeon General's report. It was contained in the section on what benefits are there to smoking for people who smoke. And that term was in the Surgeon General's report. The individual at Philip Morris who's reporting on it 10 days later picks up that term. I don't believe you're going to see any evidence of that term ever showing up again, ever, in any Philip Morris document. But if you don't have the rest of the story, you might think that's one of the rotten apples. And the other, in the last couple of minutes I have, is the suggestion that Philip Morris knew a lot about addiction and nicotine that they didn't tell anybody about. And you're going to hear evidence that in 1972, there was a conference held down in the Caribbean. And the conference was sponsored by the tobacco industry and attended by government officials, academics, public health officials, researchers, scientists, all addressing this question. Why do people smoke? The Surgeon General in 1964 had indicated there's not enough research on that question. A lot of research after the Surgeon General's report on that. 1972, there was the conference. Papers were presented by respected scientists to each other addressing that issue. Life scientists, behavioral scientists, social scientists. As a result of that conference, somebody from Philip Morris who attended, Dr. Dunn, compiled those papers and put them in a book. And he published that book in 1973, and it's entitled Smoking Behavior, Motives and Incentives. It's been around since 1973. It's available in most university libraries. I'm not sure where we got this one from, but the conference was public. The book is public. In 1972, later that year, Dr. Dunn gave a speech about the conference where he summarized what was presented. That was public. He gave an interview about this speech to the newspapers. That was public. What you saw was a draft of the speech he gave that was public. The conference was public. The book is public. The speech was public. The newspaper article was public. All of that was out and available for scientists who are interested in the issue to review. It was not a hidden piece of information that Dr. Dunn kept to himself or inside Philip Morris. But if that's all you looked at and you didn't have the rest of the story, you might conclude that. So with that, I would ask you, along with Mr. Bierstecker, to wait for the rest of the story throughout this case and not review the evidence in bits and pieces, but in totality, so that the excerpts, so that the final scene of Dragnet doesn't confuse you about whether it's a courtroom drama or whether it's a police drama. So, Your Honor, I thank you very much. I thank you, ladies and gentlemen, for your patience with me this afternoon.
Thank you, ladies and gentlemen. That does conclude what we were going to accomplish today. So mission accomplished. We're going to excuse you in a moment, but please remember that you are not to discuss this case. Nothing has changed from that instruction. You're not to do any independent research, not to do any internet search, not to have any contact with any of the attorneys or parties should you see them when you're leaving or when you're coming in the morning. I am going to ask you to be back at 9:30 tomorrow morning. And just as a reminder, this is courtroom 10A, which is different from 11A, where you were reporting last week and the earlier part of this week. So from now on, you can report courtroom 10A, and Deputy Simmons will reach you as he does most mornings to line you up and to bring you in, and we'll try to start as promptly as possible. I just wanted to remind you as well, so there's no confusion, we will have trial on Friday, and it's anticipated at this point every Friday through the conclusion of the trial, and if we vary from that, I'll try to let you know so you can plan accordingly. So is there anyone who does not understand the instruction regarding the prohibition on doing any kind of research? We're talking about the case furthermore. As you may have noted, there is media in the courtroom, so likely or probably there will be coverage this evening. It could be on a television station that you generally watch, your 6 o'clock news, your 6:30 news. You may generally pick up the Palm Beach Post, and there might be an article. You are prohibited from watching any of the television shows that cover this trial. In other words, if you see the trial that's covered, you turn the TV off or you change the station. Doesn't mean you can't go back to the station when it's over. Similarly, if you see the article or the headline, you just turn the page. You are prohibited from viewing any media. Is there anyone here who doesn't understand that? Seeing no hands. Is there anyone here who does not feel that they can follow that instruction? Seeing no hands. Okay, so that's very important. Thank you so much for your time and your patience and your service thus far, and we will see you tomorrow at 9:30 a.m.